and welcome to Rights and Recourse, a program that tackles constitutional, legal and human rights issues. My name is Dumila Matez. Today, the Rights and Recourse comes to you from the office of the Chief Justice of the Republic of South Africa, where we're talking to him about wide-ranging issues involving the judiciary in Africa and in South Africa. The last time we had a discussion on the judiciary, issues of the judiciary, Chief Justice, the Office of the Chief Justice now has its own budget, and does this mean the office is now independent of the Ministry of Justice?
Not quite, but it is the kind of progress to be celebrated. Institutional independence of the judiciary is a process. As a matter of fact, I'm not aware of any judiciary in any democracy that has not had to struggle for decades before institutional independence became a reality. I remember a Chief Justice of the U.S. Supreme Court who even had to quit his position because of the frustrations that he was experiencing from the administration in relation to the apparent reluctance or inability to do all that was required for the judiciary of the United States of America to be as independent as it ought to be. So that's remarkable progress. The administration is not as yet independent of the executive, but incredible progress has been made. The office is relatively well staffed, and it has got its own headquarters now with footprints all over the country. So we celebrate that because much of what we've always wanted to do ourselves rather than have it done for us by others is being done by those who are largely answerable to us as the judiciary.
Last year, you assumed the presidency of the Conference of Constitutional Jurisdictions of Africa. Congratulations.
Thank you.
What is the actual role of this body?
After many decades, reality dawned on the heads of state in one of their meetings under the auspices of the African Union that their agenda of realizing true democracy in Africa, of realizing constitutionalism, the observance of the rule of law, and good governance, was very unlikely to materialize absence a structure that brings together the highest courts in the continent so that they can contribute to the realization of these objectives as set out in the African Charter for Peoples and Human Rights. So we exist as the CCJA precisely to make that contribution to the realization of the objectives that the AU have set out to achieve on behalf of the people of Africa.
I've always asked these questions in these discussions around the Constitution. The fact that, do we appreciate the fact that we are a constitutional democracy? Or do some in our midst see the constitutional democracy as an irritation?
Well, it doesn't matter where you are. A constitutional democracy is a very difficult thing to handle. Whether you're a member of the executive, the legislature, the judiciary, or a business person, or even a person in the media, it's a very difficult thing to handle. Because what we fail to realize is that whatever the nature of your right, it is subject to limitation. None of our rights are absolute. So the unfortunate tendency is when things don't go my way, when things don't go your way, because we somehow seem to think that we are always right and must always be regarded as right, we act in a manner that potentially undermines the institutions and the possibility for everybody else to enjoy and exercise their rights. So a lot of teaching is required, and we each need to develop the the capacity to humble ourselves when we have, say, lost the case, humble ourselves when things don't go our way, and know that our constitutional democracy does not just exist for me. It exists for all of us. Sometimes you have it your way, but it can't be always.
Earlier, you made mention of the African Court of Human and People's Rights for Africa. How important is this court? And can it assume the function of the International Criminal Court in dealing with impunity of some of the African leaders, as they have argued?
Conceptually, it is a very important court which has a critical role to play in giving practical expression to the people and human rights contained in the African Charter. And a lot of good has come out of the African Court. But I think a lot of work needs to be done to get it to the point where, one, all African states have embraced it, it applies to them, get to the point where it is in a position to make orders that are enforceable against any institution, any body that it is allowed to make an order against. So a lot of capacitation is required. A broader jurisdiction needs to be given to it. Similarly, at a conceptual level, it's possible, it's practicable to give it criminal jurisdiction in the sense of being able to do that which the International Criminal Court is doing. But there is much more that is required for it to function effectively in that capacity. You need resources. At the moment, I stand to be corrected, but my understanding, based purely on the information that a World Bank official that I met at the AU Summit told me, a significant part of the budget of that court comes from the World Bank. We ought to be self-funding. Now, if that is true, where are the resources going to come from to finance the African Criminal Court? But that aside, maybe it's a problem that's easy to solve. For any institution to function effectively and efficiently, for any court to achieve the set objective, there must be the willingness on the part of those likely to be affected by its decisions to comply. So we all need to be satisfied that the willpower does exist from our head of states, from the citizens of Africa, to comply with whatever orders that court is likely to make. And also, just as important, is the appointment process of the judges who are to serve there. They need to be selected through a transparent process. They need to be selected by a group of individuals who are able to test the suitability for high judicial office. And a platform needs to be created by those who know the candidates better to tell the appointing authority the negatives and the positives about those individuals. Because you cannot afford, Africa cannot afford to have any compromised individual serving in any of its courts.
The dichotomy, though, is despite the court being established through the Banjul Protocol in 1998, by September the 1st, 2014, only 27 states had ratified it. What does this say about the observance of the rule of law of the continent?
My limited experience and knowledge, and I say limited advisedly, is this. There is a lot of work that needs to be done at head of state level. There needs to be a deliberate push for democracy as originally intended to be embraced by all the head of states. It needs to be truly institutionalized. There mustn't be a semblance of democratic institutions in the different African countries when practice seems to be different from reality. Once that has set in, then you'll find all African head of state embracing the African court, subjecting themselves and their governments to the jurisdiction of that court, no matter the consequences. Because respect for the courts, the willingness to subject yourself to court processes, goes hand in hand with the absolute commitment to justice. If you have nothing to hide, if you know that you are committed to doing things right according to the law, you hate abuse of power, you hate abuse of human rights, you hate election rigging, then it should be an easy thing, broadly speaking, to subject yourself to any credible machinery created to ensure that those things that you have committed yourself to, those things that you want to see happening in your country, are actually capable of being checked by independent institutions as being truly done as they should be.
We've seen regions in Africa acting differently. We've seen the West African bloc acting in a different way from the East African bloc and the Southern Africa would act, especially in hearing the case of the former president of Chad, President Hissène Habré, in Senegal. That was done expeditiously, and as we see it here, former President Hissène Habré is serving a sentence albeit in Senegal.
Yes. Well, that's the ideal. I think part of our drawback seems to be, as Africa, the negative perception that we are not as committed as we ought to be to the value of transparency and accountability. There is a perception, I don't know if it's right, but we need to deal with it, that impunity has set in certain countries. Now, processes such as the one you have mentioned would most certainly go a long way if they were to spread right across the African continent to dispel the belief or the perception that impunity has been embraced, that there is half-heartedness in our commitment to constitutionalism, the observance of the rule of law, and good governance.
You mentioned that there should be the African leaders should observe the rule of law. Recently, the African Union, I think they took this resolution in South Africa, took a resolution where they decided that no sitting head of state should be prosecuted. What does this move say about the mantra, all are equal before the law?
You know, one of the things that I think the Germans are doing right in orientating their judges on an ongoing basis is the following. The Germans subject their judges to a measure of political orientation, so that in whatever they do, they have a sense of the implications of what the implications of their judgments are likely to be on governance and the political landscape. Now, impunity should never be tolerated. But if you're dealing with a situation where consequences would still flow from your immediate and rigid application of the law or the Constitution, you have got to factor in those political implications in what you are doing. This is, broadly speaking, this is what I mean. If there is no doubt that chaos on a large scale or civil war would result from the immediate enforcement of the law, I think it may well be that you find a way, a wisdom-laden way of blending the strict application of the law now with the possibility of deferring the application of the law until the situation has stabilized in a particular country. So I think there is a need to have a broader understanding of the implications of whatever it is needs to be done. Do we deal with this person that we are convinced has done wrong now? If we deal with him or her later, would justice be undermined or served? If we do it now, what are the implications not only on peace and stability in the country or even the region and on the economy? How is that going to impact on the economy? Will the economy continue to grow in a sustainable way? Or is there a different approach that is called for now? It's a very difficult thing, which some may interpret as capitulation to the political will, but I think it requires a lot of maturity and sobriety and a lot of wisdom to manage properly.
Your assertion, correct me if I'm wrong, is a similar assertion that was given by South Africa in the case of the Sudanese president when he came to South Africa. The South African government gave the impression, the excuse, we have soldiers in Sudan. If we were to arrest the president of Sudan, we might endanger our soldiers in Sudan.
Well, I would never embrace a position like that in circumstances where a court of law has issued an order. Once there is a court order, it's got to be complied with unless you've noted an appeal. That's the bottom line. I would be undermining the very fundamentals of the existence of a court system if I'm going to say, no, even if there is a court order, ignore it because it's not politically expedient to enforce it, ignore it for whatever reason. So as I said, there is a very delicate balancing act, but when the court order is there, it just has to be enforced.
In 1998, African countries signed en bloc, with the exception of a few, to the Rome Statute. And recently, there's been rumors or murmurs by African countries that they would like to withdraw from the Rome Statute. Another dichotomy for me is the fact that this noise comes from East Africa and Southern Africa, but you don't hear this noise in West Africa. Again, going back to my earlier assertion that there's an indifference in the way we look at international jurisprudence.
Yes. You know, I think there is a lot of engagement that is sometimes necessary to normalize whatever abnormalities are found to exist or are believed to exist in any situation or institution. Before that position was adopted, I was privileged to have a meeting with the president of the ICC in The Hague. Subsequently, he, the prosecutor, and other judges of that court came over to South Africa, and we had a discussion and even delivered lectures together. What I impressed upon them was this: whether or not you believe that African leaders are right or wrong, they perceive you people as being biased. They perceive you people as being instruments of the West against Africa. Now, I said to them, I speak from experience as a South African. There is no problem that can defy a solution sought to be born out of negotiations to which we wholeheartedly committed. And the fact that South Africa is the constitutional democracy is the best example one can ever hope for. Now, go and seek a discussion with the African leaders. Dispel the perception so that we can differentiate an excuse intended to entrench impunity or to run away from justice from a genuine concern that can be addressed by a meaningful engagement with the officials or the judges of the ICC. I don't know if that engagement ever took place, but I have a reason to believe that had there been some engagement, a lot of good would have come out of it. So I'm not too sure what motivates different regions from approaching the ICC differently, but my bottom line is this. None of us should ever be allowed to assume a position of leadership and not subject herself or himself to processes intended to test whether he or she has been true to the dictates of the Constitution, human rights in particular, and the laws in his or her country. When there is reason to believe that violations, particularly gross violations of human rights, have taken place, we all ought to avail ourselves to stand the test of scrutiny.
When we come back, we'll talk a lot more around the issues of separation of power, judicial overreach, and judicial activism. Stay with us. Welcome back. Chief Justice, we have seen recently courts on the continent, in Kenya and Liberia, taking a strong stand, making sure that elections that are held on the African continent are credible. Is this what courts on the continent should be doing?
Courts in Africa and elsewhere in the world exist precisely to make sure that the Constitution and the laws are respected, to make sure that we're all equal before the law and nobody has the possibility to act as they please in disregard of the Constitution and the law.
During a question and answer session at the last CCJA conference, I hope I'm saying it right, this question was posed to you. You have linked the role of the judiciary in the promotion of sustainable development, but could you comment on aspects of the rule of law that link solely to development, such as protection of children, women's rights, and disabled people's rights? We've had a lot of stories around children's rights, women's rights, and disabled people's rights in South Africa.
Yes. Well, the rule of law cuts across everything. The rule of law exists to make sure that citizens, including children, including the physically challenged, everybody, men and women alike, enjoy fully the rights that the Constitution and the law accords them. So the rule of law, remember, exists to make sure that nobody occupies a position of authority and fail to do what they were appointed to the position to do. If it is to look after and advance the best interests of the children and people with disability, then they've got to do just that. How does the rule of law come in? When they fail, they must then, if those senior to them don't do anything about the failure, be taken to court so that the law can find expression.
There's been a great deal said about the doctrine of separation of powers. What in essence does this doctrine represent, and how should it be observed?
The doctrine of separation of powers boils down to this. We have three arms of the state. The executive, generally led by a president. The legislature, in our case, is led by both the Speaker of the National Assembly and the Chairperson of the National Council of Provinces. And the judiciary in our country is led by the Chief Justice. Now, the tendency, and this is what creates problems for us, is to elevate the executive above all else. Where that happens, the legislature and its role gets undermined, the judiciary and its role gets undermined. They begin to look like imposters who come across as wannabes. They want to look like they are more important than they really are, when in fact, raw power resorts to the executive. that entrenches a weakness in the governance system. Because sooner rather than later, you find members of the executive wanting to impose their will and actually succeeding to impose their will on the legislature and the judiciary. And when, for instance, a court makes a decision that is not favorable to members of the executive, people get surprised. How dare they? Who do they think they are? They have not even been elected, these people. But separation of powers is about checks and balances. We as judges, and our judgment in UDM seeks to articulate separation of powers and what it entails. We as judges get appointed in a manner that represents not only judges and lawyers who are in practice and in the academia, but also politicians who are in parliament and members of the executive. So that gives credibility to the appointment process as it relates to the judiciary. So we are a legitimate constitutional organ. And everything possible must therefore be done to make sure that we have all the resources, we have all the capacities to do what the Constitution requires of us to do. Now that means our independence and our administration of justice is not honored only when we make decisions that are against the executive. And that is the problem. We need to educate our people. People think that you are an independent and progressive judge when you make it your business to always speak strongly against Parliament, always speak strongly against the executive, but never speak strongly against the private sector and opposition parties. It's like, you should be one of us. Help us to deal with these people. That is corruption of the judiciary at its core. Any parliament that is favorably disposed to any of the two organs in circumstances where it is required to be forthright and tackle its duties properly is corrupting itself. So in essence, it's a checks and balances situation. We administer the laws that were made by Parliament. Some of the things we go about were done by the executive. All this must be done without fear, favor, or prejudice. That's when democracy will work.
Where does this leave judicial overreach?
You see, judicial overreach comes especially in circumstances where we allow intimidation and fear to filter through. Let me tell you how it works. Many people believe that it is only those who are in government who have the capacity and the possibility to instill fear and to intimidate. The truth of the matter is, quite often, they are the ones who instill fear. They are the ones who have the possibility and the capacity to intimidate, but they are not the only one. Mr. Matesa, you're a journalist, you can intimidate the judiciary. You can make it your business to structure your stories in such a way that you profile certain judges and magistrates because what they say and the judgments they deliver coincide with the interest behind the media house that you come from. The reality is there is no media house that just jumped from the earth or from the tree. Human beings come together to establish a media house with a particular objective in mind. And quite often, they've got a political outlook. They subscribe to certain ideologies. Now, the tendency around the world is this. When you are so independent as not to be wooed over by vested interests, a smear campaign starts around you. There is a degree of marginalization that becomes so apparent people now cease to even be ashamed to display it. Others are not as brave. That has been proved. They position themselves to be celebrities, to be the favorites of the medias or some powers that be, so that those who have the possibility to speak loud and to talk, those who have a voice in the public domain, can be praising them all the time. That's when you corrupt the system. Judicial overreach happens when you stray beyond the parameters, when you seek to adopt a dictatorial posture in relation to the other arms of the state. The executive should not go beyond certain bounds in its interaction with the judiciary. Parliament should not cross a particular line in its dealings with the judiciary. Otherwise, there will be a parliamentary overreach. Otherwise, there will be an executive overreach. But similarly, the judiciary has got parameters within which it must function. Once it begins to act as if it can do as it pleases, it is the only arm of the state, then you have judicial overreach.
Does the judiciary encourage judicial activism? And can a sitting judge be involved in judicial activism?
Absolutely. We do that all the time, don't we? As long as it is within constitutionally ordained parameters, that's perfect. Let me give you an example. If you look at how we approached the IEC matter that came here, I think it was last year, when it looked like there was no way open to this court to resolve what seemed to be a constitutional crisis, a lot of judicial activism was called for. A lot of judicial creativity was required to avert a possible constitutional crisis. So our activism showed its hand and showed it very strongly. When you look at even the SASA matter, a lot of activism was required of the judiciary to avert a possible national and constitutional crisis. So it is something that is there. We practice it, but alive to the parameters within which we ought to operate. The problem with judicial activism will arise when you turn a blind eye to the parameters within which you ought to operate and go overboard. When you act as if you are not bound by the Constitution and the law, you are the law yourself, you are the Constitution yourself, that's when the problem is going to arise with judicial activism.
I don't know whether I'm right, correct me if I'm right. I am reminded of Judge Anton Mostert in the 70s, who defied Prime President P.W. Botha and blew the lead of corruption and the misuse of millions of rands of public money by the then Department of Information, and shocked the legal profession by resigning from the bench afterwards. Could that be said as judicial activism?
Absolutely. He chose to do the right thing. How do you cover up for corruption? Just because others would want you to? You don't deserve to be a judge if you go into.
The other question that has been spoken about recently, the Traditional Courts Bill, is presently before Parliament, and there's a great deal of wrangling around this piece of legislation. How does customary law, such as the leadership of the traditional chiefs, fit in a constitutional democracy?
Well, the Constitution recognizes traditional leadership. That's a starting point. But the reality is all of us, including traditional leaders, are subject to the Constitution and the law. None of us has the right to be exempt or immune from the application of the Constitution and the law. But traditional courts have a very critical role to play in enhancing access to justice. Just to give an example, when I went to attend an international conference in Rwanda, the thrust of the conference was how to make justice accessible through a traditional court system. I was shocked to realize that in Rwanda, for instance, after the genocide, After some 8 years, there were about, I think, 120 cases that the tribunal was able to deal with, and there were way over 1 million cases that were waiting for their turn. A realization dawned on all of them that it was never going to be possible to deal with all these cases in a lifetime. And it occurred to them that a traditional court system that is structured in such a way as not to undermine the constitutional rights of the citizens could be the avenue that should be resorted to dispose of the many cases. And when the idea was presented to the nation, they welcomed it. Why? It is the type of law that they can relate to, the kind of legal procedure that they understand. They don't even need a lawyer to participate more meaningfully in that system. And in a very short space of time, we were told that over 1 million cases were disposed of. Other jurisdictions, for instance, Malawi, Tanzania, and so on, resolve most of their cases through a traditional court system which lays more emphasis on restorative justice rather than imprisonment. So I believe that a properly structured traditional court system that is compliant with our Constitution, the Bill of Rights, that does not discriminate against women, is the solution we need to alleviate the court system of the burden and the delays that have turned into a frustration to the many citizens of our country. We need to restructure our traditional court system. We need to capacitate the traditional leaders and those assisting them in the running of the traditional courts so that everybody understands how this can be done properly. Happily, the South African Judicial Education Institute that I chair has begun to offer training to traditional leaders so that as they preside in these courts, they would be properly capacitated.
The former Chief Justice of Kenya, Justice Makau Mutua, says there must be a distinction. A distinction needs to be drawn between the law and the rule of law. The two terms are often conflated.
He is right. They are different. The law is not the rule of law. The rule of law is about ensuring that those in positions of authority do not exercise the authority they do not have, the authority the law does not give them. It is also about ensuring that we do not ignore our legal responsibilities or obligations. In a nutshell, the rule of law is about ensuring that we operate within the parameters of the law and we subject ourselves to the dictates of the law. That's, in a nutshell, what it is about.
The other thing for me, I've been grappling with this for some time. A case was brought to this court by the EFF around Parliament not having created the rules to hold the executive and the president accountable. In the court ruling around the Nkandla debacle, Parliament itself did not come out of that case smelling of roses. Therefore, Parliament itself needs to look at itself, isn't it?
Well, everybody needs to look at themselves. I mean, you may wonder why we have so many layers in the court system itself. You start at the small claims court or the traditional court. You go to a magistrate court. You can even go to the regional court, high court. There's an appeal system within the high court. You go to the Supreme Court of Appeal, and then you come to the Constitutional Court. Why? Precisely because any institution run by human beings, mere mortals like you and I, is not free from error. So they make mistakes, and we are at a teething stage, really, of our constitutional democracy. We're still grappling with how best to do our work, how best to operationalize these institutions within which we function. And there are other challenges best known to those who function within these institutions as to why they're not always doing what they ought to do. But the bottom line is this: happily, there is separation of powers, and that allows the judiciary or the courts to be approached to say, this is not right, this is what you should have done. Happily again, when that has been done, when the courts have spoken, broadly speaking, there has been compliance.
South Africa has dropped one position from its overall rule of law performance to 44 out of 113 countries in the 2017-2018 World Justice Project Index. What does it say about our adherence to the rule of law?
Well, that must be pointing to the fact that there are challenges in our adherence to the rule of law. But I must also say that, the World Justice Project must also up its game. I had a meeting with them here at some stage, and they were saying that there is corruption in the South African judiciary. My colleague who introduced them to me, Goldstone, Richard Goldstone, was shocked when I told him these people say that the judiciary of South Africa is corrupt. And I asked them, how did you arrive at this determination? They say we spoke to people. I say, who did you speak to? And what did they produce to satisfy you that there is corruption within the South African judiciary? I discovered that they would go to people in the street and ask them, is there corruption in the South African judiciary? Yes, there is corruption. These people are taking bribes. No empirical research. So I'm not denying that there are rule of law challenges. I'm not denying that there are times when court orders are not complied with. Of course there are times when court orders are not complied with. But we would do well to steer clear of generalizations as bodies that must help us to do the right thing at all times as we discharge our responsibilities.
Wearing your hat as the president of the CCJA, Burkina Faso and Kenya saw the biggest improvement in rankings amongst the 18 countries indexed in the region, while Madagascar experienced the biggest decline in rank, dropping 8 spots. Could there be an improvement, looking at the improvement of Burkina Faso, which is not a country with all the riches of the world, and Kenya?
Well, there is room for improvement everywhere. And I just think that what could add impetus to the improvements that we are noticing in other African jurisdictions would be an absolute commitment to this year's theme of the African Union, which, as you know, is winning the fight against corruption, a sustainable path to Africa's transformation. You will find challenges around the rule of law when incidents of corruption are not tackled head-on and promptly as they should. But once good governance has undoubtedly set in, you'll find very few incidents that give you reason to be concerned about our commitment to the observance and promotion of the rule of law.
I know that case was supposed to come to South Africa, to this court, the threatened withdrawal by South Africa from the International Criminal Court, and it was not brought. But what is your view with regard to participation by South Africa and other African countries in the International Criminal Court processes?
Well, my view very broadly would be this. It is a matter of choice which international body or institution you subject yourself to, or you continue to cooperate with. The bottom line, though, is this. whatever you do, make sure that you do it in terms of the law. What would even be more comforting to the people of South Africa, from my view, is to inquire of them, as our public representatives, this is what we think needs to be done. It's a very serious measure, because if any of the future leaders of this country were to be involved in gross human rights violations, the need to have the person dealt with, and dealt with properly, would arise. Would our withdrawal from the ICC undermine the possibility of that leader being properly and firmly dealt with? Or can the public be assured that our withdrawal would ensure that, even at a continental level, a structure would exist that will enable South Africa to be dealt with as firmly as it ought to? Happily, speaking for myself, we have a judiciary in this country whose independence is, in my view, beyond reproach, and should any incident of gross human rights violations or any human rights violation happen, the judiciary of South Africa would be equal to the task of ensuring that whoever the perpetrator is dealt with firmly internally.
Students of law regard dissenting judgments as very important because they learn from them. How important are dissenting judgments?
The first significance of a dissenting judgment is this: it bears testimony that judges do not robotically just support a particular position. And also, it bears testimony to the following reality: that contrary to some cynicism, that before we can even read the papers, we check who is involved. This one must be dealt with. How do we justify the decision that we have already reached? It's demonstrative of the reality that South African judges apply their minds to the issues, and because they have different brains, different experiences, it is not always that they are going to agree on the outcome. It is not always that they are going to agree on the reasons for the outcome. So that's the significance of dissenting judgments. And what has happened over the years has been this: a dissenting judgment of today have, after some years, proved to be the majority judgment of the time. So that's the crucial nature of dissenting judgments. But also they enhance a better understanding of the majority judgment. The majority judgment also enables people to appreciate some of the challenges or weaknesses in the minority judgment. That's the vibrancy that ought to obtain in a truly independent judicial system.
South Africa's constitution is celebrating 21 years since its inception. Do you think there still needs to be a great deal of education that takes place among South African citizenry around the constitution?
I think we haven't even touched that space yet. A lot needs to be done by print media. I think we would serve our nation very well if from time to time there are columns dedicated just to educating our people on their rights and their responsibilities, educating people about how different institutions of government ought to operate. But also radio and television would do well to dedicate time to educating the nation about the Constitution and the law. And broadly speaking, we would do well as media houses not to have our own analysts. And this is what I mean by our own analysts. Analysts who are predictable in relation to what they are going to say when we are talking about issues affecting a particular individual or a particular institution. Analysts who act as if they will never be allowed again to feature in programs if they were not to toe a particular line is becoming too glaring these days. Before a person even opens his or her mouth, you can tell, okay, on this issue and about this personality, about this interest, this one is very likely to say this. I would be shocked if he or she doesn't say that. But there are also a good number of analysts whose objectivity is beyond reproach. They just look at the issues. You need those analysts to teach the nation about their rights and how institutions ought to work. This being the year of Nelson Mandela, even so declared by the African Union, by the way, to ask ourselves a question: what is it that I can do for my country and for my people? What is it that I can do for my continent and the people of my continent? It's time to sacrifice. It's time to be selfless. It is time to read more, empower ourselves through knowledge, so that we are never again misled by people who are pushing their own agendas at the expense of the national agenda and the common good of all of us.
On that note, Mr. Chief Justice, it's not every day that you get an exclusive interview with the Chief Justice. Thank you very much for your time.
Thank you for the opportunity.
Thank you for watching this special program with the Chief Justice of the Republic of South Africa. Please continue tweeting and send your emails about this program and many others to rightsandrecourse@sabc.co.za. From all of us, goodbye.